All right. Welcome to unCOMPlex for September 2024. We are going in a pre-recorded format today because this backs up and conflicts with another item on the schedule. And so this is going to be one of those rare exceptions where we're doing this in a pre-recorded format. There is no live interaction on today's broadcast. So sorry for that. I have some things that I'm going to share and demonstrate, but upcoming events first. We have the OJCC Academy coming up in October. That's going to be October 18 at the OJCC office in Orlando, up there in Seminole County, just across the line. That is going to be a day-long adventure and exposition on basic workers' compensation for those that are younger or newer to the practice of workers' comp. We would love to see you. There's still probably a few opportunities available to jump in on that program. You can email me at david.langham at doah.state.fl.us if you're interested in attending, and we'll be closing that out reasonably soon, but it's not closed out just yet. So I'm popping up to share my screen and just show you a thing or two over here. Um, the information that I talk about so often is usually on the blog, and so hopefully I'm sharing the right screen. So the blog is right on the front page of the website, and some of this stuff may be interesting to you in history, but the announcements is really the primary driver. And our first up on the announcements page right now is our Scholars Program. We kicked off the Scholars Program with some lawyers that and others, lawyers and industry folks that we think are going to be part of the future of this community of workers' compensation in the state of Florida. We're really proud to have brought this group of people together, and we had a wonderful opening session at the WCI on Tuesday. What was it? August 20, goodness, August 20th. Um, so it was a very good program. We got off to a great start. And I think that we are really expecting that program to go places. We had discussion about comparative law, the origin and roots of workers' compensation, both politically and historically. And I think this provides a foundation for folks that is really critical that we have some people around that understand where this all came from. I also did a short bit on the economics of Florida and how the state came to be what it is. All I can tell you in a short moment is that Florida is really a unique and special place in terms of climate, in terms of topology, in terms of geology, in terms of the people that have come here and those that have stayed, the colonial period. Just a fascinating piece of real estate that we all share here. And it was really interesting to get together with those folks and talk about it. I wanted to show everybody the Mediation History in Florida project that we've got going. Some of you know that I have written a book that has just been published regarding the history of the Office of Judges of Compensation Claims, and in the broader context, those who have adjudicated workers' comp claims in Florida. And admittedly, over the years, there have been some pro hoc vice adjudicators, but I managed to find 260 appointed adjudicators that have served either as a deputy commissioner, judge of industrial claims, judge of compensation claims, or deputy commissioner the second time we used that term, or they served as members of the Florida Industrial Commission, the FIC, and the FIC was in charge of workers' comp from 1935 into the 1960s. To this day, the greatest portion of our workers' comp history still covered by the FIC. And a lot of people don't realize this, but back in those days, there was something called the Florida Compensation Reporter. And so these are the decisions of the Florida Industrial Commission The Florida Industrial Commission, of course, ceased to exist in the 1970s, and we had the Department of Commerce step in and take over workers' compensation through the uh, Department of Labor and Employment Security as the adjudication side and regulatory side. And of course, with that, there was the Industrial Relations Commission, the IRC, and the IRC provided our appellate practice and review until the IRC was likewise discontinued, and in came the era of the First District Court of Appeal. Back before that, the IRC would do appellate review, and their decisions were only reviewable by the Florida Supreme Court. And so, again, that mode is much more proportionate in terms of our history than the history of the Florida First District Court of Appeal being involved in workers' comp, but that's starting to shift. And the period of the DCA, the era of the DCA, is coming to represent the majority of our history at this point. I'm working on a similar history with the mediators. So what I've published here in the announcement blog is a list of the mediators that I know of, and I've missed a lot. I would sure love to hear from you if there are mediators you remember, state mediators, that were involved in this practice and that served in one of our district offices across the state. I'd like to get this list complete, and then I'd like to do a little bit to address the history of those folks and their various contributions to the success of workers' compensation in Florida. I think it would be super for them to have a bit of recognition and for all of us to reflect a little bit on the great job that all of them have done over the years in terms of keeping us salient and functional. So if you want to go to the announcement blog and have a look at that, we sure would appreciate it. Time and again, I hear from folks who want to talk about emergencies. And emergencies happen. We see that literally all the time. I wanted to put up the favorite picture of any picture on the internet. This is my favorite one. I love tuning in. I do this every day this time of year. I love it when it says no cyclonic activity over the next 48 hours. That's my kind of picture. And hopefully we'll see that a lot more in coming weeks as we muddle through what's generally the worst part of the hurricane season, which is September and October. But what do you do if there is an emergency? Well, first of all, when in doubt, folks, look to the rules. And our rules right here in 60Q have got emergency office closures already defined. So we know what's going to happen if there's an emergency is if the circuit courts close in the county where our office is located because of any kind of disaster, then our district office is going to close. You don't need to call or email and say, well, the courthouses are closed in Dade County. What does that mean for the Miami comp office? It means it's closed. You can get that information from us. We have a posting up on the blogs. So right here in the announcements, for example, when Debbie struck in August, right there we started posting, and we posted all about what was going to happen with the closures. The Supreme Court, it says right here, announced closures of courthouses in the red counties, and that included the courthouse in Tallahassee. So our Tallahassee office shut down. Later, later in the day, after that map was printed, the Supreme Court announced closure of the Duval County Courthouse. So likewise, we did the same thing. Duval County Courthouse closed August 5, right there and highlighted for you. So you can count on the fact that if the courthouse closes, we're closing, and if the courthouse is open, well, then we're open. If you have emergencies, and you cannot reach the judge, the assigned judge, you're welcome to reach out to me on my email, but that would be ex parte unless you copy all of the parties involved. What am I going to be able to do for you? I can verify an office is or isn't open. I can verify for you that we don't know status as yet in a particular location or office. I'm not going to grant a motion for you. If you've got something that requires a motion, you'd like to have a continuance, you'd like to have a subpoena quashed or something like that, you need to go ahead and file that under 60Q 6.115 with the assigned judge. You say, but I'm not sure the judge will get it. Well, he or she's going to get it rapidly enough, and I'm not going to step into their case absent some sort of cataclysmic system failure. And so keep that in mind. Uh, Probably best not to send me motions, but if there's an emergency, for instance, if our filing system goes down, well, what do you do? That something has to be filed. You're on a deadline. You're counting days as regards a time for response or a time for a notice of appeal. If you're in that kind of difficulty, you're welcome to send me a notice of appeal by email, and I will mark that as filed on that particular day. And hopefully, we won't make that into some sort of an issue that challenges us. It shouldn't challenge us. We'll do our best that it doesn't. You should know that the Supreme Court posts these maps on their website, so you really should pay attention to the Supreme Court closures. You can get to that anytime if you simply go to the URL bar, and if you put in Florida Supreme Court and weather closures right there, it's going to pull up the weather-related emergency orders right there from the court. And you can see today everything is open, and that makes sense. We just looked at the map, right? But this will tell you what is going on, whether any of the DCAs are shut down, etc. Um, this will help you a great deal in all likelihood in keeping up with what's going on with us in an emergency. You can also follow us on Twitter. You can follow us on LinkedIn. You can follow us on Facebook. And all of those will have periodic announcements anytime we're in an emergency situation. I encourage you to tune in and have a look at that. I wanted to talk a little bit about the mediation privilege. We know from 440.25 that the whole mediation process is privileged. You also know that our mediators are all certified by the Supreme Court, by the Dispute Resolution Center, the DRC, and because of that, uh, the mediations are confidential, both statutorily and by court decree. And we could argue about whether the court decree means anything, but the fact is that the court decree governs the mediators, and so they're bound to keep the mediation confidential. That confidentiality is about when you tell the mediator about your perceptions of the case. That confidentiality is if the injured worker or the employer wants to speak up and tell really anybody about the case, including the other side, because what's said at mediation, sort of like Las Vegas, stays at mediation. I apologize. That's a horrible joke. Vegas. Strike that. But it's important that the mediation privilege covers that so that you can speak openly and frankly in trying to better understand your position and trying to better understand the other party's position or positions. That communication is very important and critical. What's not privileged? We've run into this a little bit lately, and this is disturbing. It's troubling to me. The F-bomb is not confidential. It's also not appropriate. It's also not polite. It's also not professional. My goodness, there's lots of things that the F-bomb isn't. The F-bomb's not welcome in mediation. Uh, the F-bomb's not funny. I could go on for days. At the end of the day, we don't need people using abusive language. We do not need people screaming at our mediators or at opponents. We do not need people using other coarse language, expletives, or profanity. Mediation is not the place for any of that. The mediator says that she or he needs something from you. That means that they need something from you. We don't need arguments about, well, you don't need that, or I'm not giving you that. Obviously, the privilege is yours to protect. And so if there's something that you're not going to share, we'll certainly accept that answer. But it's your job to explain to us why. Why are you not providing that? Why will you not let the mediator speak to your client? Is that is that valid participation in a mediation? If the lawyer attends but will not allow the injured worker or the employer or carrier to hear what is going on directly? That's an excellent question. We can solve it easily without getting too interested by simply saying the point and purpose of mediation is communication. It's to break down barriers. It's to have discussions that are frank, open, and honest, that are not necessarily perhaps filtered. I would encourage you to give serious consideration to whether someone appearing at mediation is mandated by the statute. And I think you'll find some folks who will agree that it is, that participation in mediation means showing up. Now, does that mean that you have to negotiate? We just had this wonderful conversation at the National Association of Judicial Workers' Comp Judiciary this last week in Orlando at WCI. And we talked about whether the parties have to make an opening offer, make a demand, and the answer to that is unequivocally no. Mediation in Florida is mandatory, mandatory in the sense that the parties are going to show up and they're going to listen to the mediator. That is, listen to the mediator, tell them about what process looks like and what mediation means. That doesn't mean there has to be an offer, does not mean there has to be a, a, a demand. It means that we've got to show up and understand what the process means. And if we do that, and then you decide you don't want to participate anymore, you are by all means entitled to your impasse and your departure. That's what we call in the mediation business the concept of self-determination. And self-determination is ultimately very important in our dealing with the way process works and in making sure that the parties are actually getting what they need and want out of this process. Apologize for being distracted a moment. I just turned the ringer off on my phone. Something I have to remember to do from time to time. This podcast is being broadcast on September 11th, and that is a day that will, to steal a phrase, live in infamy. And so I hope that you are cognizant of September 11th, cognizant of what it means, what occurred that day, and the tragedy, the death, the destruction that was wrought by those uh, misguided, angry terrorists as they committed those acts here in our country and affected so many. It is the sort of thing that you'll remember. I encourage you to make a note of things as they occur in your life. You're going to want to, at some point, perhaps reflect back on September 11th and remember what you think about it or thought about it at the time. Or quite possibly some of the folks tuning in for this may have reached the point that I'm talking to people that are born since September 11th, and maybe uh, they have a little less of a perspective on it or a recollection of it. But it was a big deal, and other big deals will happen and have happened. The COVID-19 pandemic certainly was in that vein, and so it's important for us to remember that these big events do happen and occur in our lives, and that can have a serious impact upon us. Finally, in a broad context, I just want to mention the stay of proceedings again. Judges of compensation claims don't have authority to stay a case. The Supreme Court of Florida has dealt with that, has opined. We are not a court. The Office of Judges of Compensation Claims, not a court. I used to joke that we were a half gallon at least, and some of us were a gallon, and a lot of folks took displeasure with that quote. I thought it was funny. My apologies. But we're not a court, So we don't have any inherent judicial authority. What we can and can't do is set forth in Chapter 440 of the Florida statute. So if you're looking for relief, the best thing to do is file a motion. And the motions that are the most likely to move rapidly across the judge's desk, whether to approval or denial, are the ones that cite authority. One of the great pioneers of our computer age was quoted years ago saying, "In God we trust, all others bring data." And that has a lot of merit in the litigation process generally and in workers' compensation specifically. If you are entitled to some relief, that is, you are entitled to have the judge tell the other side of the case to do something that you would like them to do, or stop doing something that you'd like them to quit, the motion under 60Q 6.115 is probably your best shot at moving the case forward. It says for any order or other relief, you file a motion with the judge. So file that motion. If you want to stay, you're welcome to file it, but understand nowhere in Chapter 440 does it say that we can stay a proceeding. Continue? Absolutely. That's in the statute. Uh, is the reason for the continuance a good one? Um, is something that you would stay a case for just as valid a reason to continue it instead? I think these are sound analyses to go through. Um, what if you already have a stay and the stay was handed down or issued by a federal court or a bankruptcy court or a state court that says that we're supposed to stop what we're doing, or the litigation in a particular case is supposed to draw to a momentary pause? Well, why not just file that motion to recognize or motion to accept that order from the Eastern District of Missouri staying proceedings in cases against XYZ Corporation? If a federal court has already stayed proceedings and said nobody can hold hearings as regards this litigation, well, the Supremacy Clause, the U.S. Constitution, says that applies to me. And that sort of overarches and overreaches Chapter 440. So if you want me to stay the case, not sure I've got the authority. You're going to have to show that to me, right? Show me the authority. Bring data. Or you might find it simpler to simply move for continuance and say we've got this stay that's been entered in Montana and it's ongoing. We're under the initial 90-day stay and we need a continuance of this trial. I think that makes things a lot more clear and a lot simpler for the trial judge to jump in and say, I'm going to do what I'm going to do. Apologize for taking a drink. I'm a little dry today. Some of you would probably say I'm a little dry every day. I'm doing my best. Tell a joke or two here and there. Uh, it's hard. You tell a joke that doesn't offend anybody. You got to make fun of somebody that either doesn't get the joke, like judges. I didn't say that. Or fictional characters. So it's getting kind of tough. Anyway, so you understand stays. We talked about ex parte. If you're going to send something to any of the judges or the mediators, you really ought to copy all sides with it. Make sure everybody stays on the same page. So I had a wonderful opportunity at the WCI to sit on some panels. I know that there are way, way more programs at that conference going on simultaneously than you can ever get to. And so it's very difficult. You find yourself at a conference like that, and there's lots of programming that you'd like to get a piece of. So I thought I would share with you some perspective or some thoughts from the programs or panels that I sat on. The first one was on artificial intelligence, and I was privileged to sit with Dr. Chris Brigham and a spectrum of other speakers, and we talked about medico-legal interaction and the challenges that we all face from a artificial intelligence perspective. Key takeaways. Number one, artificial intelligence today is nowhere close to where it's going to be. There seems to be a general consensus that AI today is sort of the equivalent of the Radio Shack Tandy computer of 1978. We're going to look back in 10 years on AI in 2024, and we're going to laugh at ourselves because we were impressed with it and we used it and we thought it was going to change the world. It's going to change the world, but what's really going to change is the AI that this AI comes up with, and as it further develops and evolves down the line, we're going to find that what exists a decade from now will be every bit as different from what we see today, as the iPhone is different from a flip phone. The world is evolving, and this AI is going to evolve just like it. What is it going to do? There seems to be also a general consensus that AI is going to, if not replace, certainly displace a volume of uh, employees that today are doing tasks that are at least arguably rote or repetitive. AI is going to take over the sorting of documents, the summarizing of documents, and we had a great conversation about whether a summarized document produced by an AI is better or worse in terms of its evidentiary value. And the answer is so simple, it just slaps you in the face if you give it a chance. The answer is it depends. And it depends on whether the AI has done a good job. But the same is true if a human being does a medical record summary, folks. It still comes down to you, the lawyer that's going to try the case, or you, the lawyer that's sending this off to an EMA or an IME to review. Your job is to look through that summary and make sure that you've hit the salient points. Are you taking care of business? And if you are, then maybe the doctor wants to hear from you on a video like this or AI video, or maybe she doesn't. Maybe she just be everybody's happy with that written medical record summary. Then whose job is it to communicate with her and figure out what works, what doesn't, and make sure you get the job done? Well, it's everybody's responsibility. Another thing we did last week was a nationwide coast-to-coast review of case law, and that was absolutely fascinating. We did all 50 states, and myself and four other panelists got up in front of a room full of about 70 people, and we rattled through those cases for the most part in less than a minute each. We had a couple of folks that were a little more long-winded, and we had some nice questions from the audience that tend to stretch things out because people are trying to focus us in on a narrow piece of a particular case or statement. And so that's going to strengthen the value of the presentation, but it's also going to cost you a little time. But for the most part, about a minute each. And what did I pick up from that? Uh, number one, number one, if you enter a stipulation, get prepared to live with it. The stipulation is probably going to control your future dealings, at least in this case. How could that be important? That was in a Florida COVID-19 case about a person entitled to a presumption. And once they got to litigating over the actual benefits in the case, the employer carrier was less than pleased with the way the math worked out, and they took an appeal and said we should have been able to rebut this presumption. And the court said, well, essentially yes, but you stipulated that the employee didn't meet these criteria, and so that's sort of the end of the analysis for that injured worker. Not abnormal, not different. We found cases also stood for the some of the most striking propositions. Contracts matter, just like stipulations. We were reminded that accidents in the vehicle while going to and coming back from work are not compensable, and that there are various exceptions. I would suggest to you that a big part of our focus was really that not only can you change these outcomes, but to do so, you have to do a little forethought, little planning, so that you're prepared to facilitate the fact that somebody's hospitalized or otherwise unavailable, and you want to be able to deal with that situation. The uh, the other intriguing piece of the puzzle in terms of case law was discussion about the various value of benefits in different states. An appellate decision in Mississippi pointed out that just because the employer was incorporated and headquartered in Mississippi did not, under their statute, give the workers' comp system jurisdiction. Now, that may or may not be the same in Arkansas or Indiana or Illinois, but what it should teach you and what you should pick up from that little bit of workers' compensation trivia is that the statute will define where an injury might or might not be compensable. And so you can work your way through the process and better understand where you might file the case. Why would it matter? I would suggest to you that it might matter if you're on the claimant side because some states the employer picks the doctor, other states the claimant picks the doctor. Is that more important to you to be able to pick the doctor? I don't know, but it's something to think about. One state has a 66 and two-thirds cap on their indemnity. Other states maybe don't. If you've got a choice between filing in Florida and Iowa, I would suggest you might want to look into it. But over the years, we've learned that just comparing Florida to other states that are up the East Coast can also make for some pretty interesting math analysis. And you work through these problems. Finally, the case law update gave us a chance to look at a variety of instances in which presumptions are being interpreted and dealt with across the country. The bottom line is that various states have worked on presumptions. They're going to keep working on them. One of our conversations had to do with the Florida case in which the firefighter or other first responder uh, accepted the quote unquote alternative to workers' compensation. And and then after the firefighter or first responder passed away, the widow or widower decided to go ahead and pursue workers' comp. The employer's response was the statute says alternative, and that's all well and good, but the employee, the estate rather, was able to point and showed that elsewhere in the statute, it doesn't say in addition to, it says that you can get both, and so that's a conflicting piece of statute, and the court has ruled that that means that the ambiguity is going to create the potential for that alternative that instead of being in fact an and. So that's been a pretty good overview of where we're at and where we might be heading. I appreciate that this was pre-recorded, and that's troublesome. But the fact is that we are uh, double booked this particular Wednesday, and we're going to do better come October in being available live and in person. And we'll get together then. We'll talk about workers' comp, what it is, what it isn't, what it might be. And we will all try to do a better job moving forward based upon that knowledge and experience that we've gathered. So that's the end for today. I hope you enjoyed this and I hope you got something out of it. I look forward to seeing you again in about a month.